we will get going. So good afternoon, everyone. I am Ian Friedman, and I'm the president of the Cleveland Metropolitan Bar Association. I'd like to welcome you to our first Fireside Chat. And as you can see, I've taken this very seriously with the fireplace, and our CEO, Becky McMahon, made sure to or reminded me that I had to make sure to be here with elbow pads and the whole bit. So I point this out. We are really taking these fireside chats seriously. And in that light, we could not be kicking this off with a better guest than Ohio Supreme Court Justice Judith French.
Thank you.
Justice French, welcome and thank you for being here today. This is really fantastic. The viewers who are coming from not just the CMBA, but from across the state are really excited to hear what you have to say and, and learn a little bit about who you are.
Yeah.
So welcome.
Yeah, well, thank you. I really appreciate being here, and you have really raised the bar on backgrounds. So, it's not even virtual. You got a real fire going. So I'm envious, but I'm going to be up to the challenge next time.
Well, I will tell you, just so that you're not overly envious, it's a little warm right now. So, but I thank you for giving me the occasion in which to get dressed in my own home.
Yeah.
It's been 7 weeks, and so thank you.
Yeah.
I want to remind all of the viewers that you can ask questions in real time through the chat feature on the Zoom program itself. Our CEO, Becky McMahon, will be getting all of those, and she will be forwarding those to me in real time so that hopefully we can get to your questions as well and have Justice French answer those. So without further ado, I guess my first question would just like to know a little bit about you, and you can tell us, what your path was to sitting on the Ohio Supreme Court.
Sure. Well, my path was kind of an indirect one. But it started in Northeast Ohio. I'm from a little town called Sebring in Mahoning County. Grew up there, went to Ohio State, and went to Ohio State for law school as well, and graduate school. So I started my legal career as an environmental lawyer at Porter Wright, and practiced with that firm for several years, and then a corporation, and then a state agency, and then the Attorney General's office, and then the governor's office, and eventually to the Court of Appeals. So my the path to the Supreme Court really started with a chart of the justices' birthdays. As you know, you can't serve as a judge once you're past 70, and so I found out when their birthdays were and made a little chart of when a seat might be open, and started talking to people about eventually becoming an Ohio Supreme Court justice. So I look back on that over 30 years, and I'm just so pleased and honored to be where I am now.
Great. So at what point, there had to be a point in your career, you talked about doing the birthday chart, but when did you first realize you had that itch or that desire to be a Supreme Court justice?
Well, even before then, even deciding to become a candidate was really a hurdle. I was in the governor's office, and there was a potential opportunity to go to the 10th district. And I really said no for a long time, saying, I'd love to be a judge. I mean, being a judge would be great, but do I really want to be a candidate? And that was the hurdle that I really had to get over, was, do I want to put myself out there in that way and give up a job and put everything on winning an election and going to the Court of Appeals? And the way that I decided to go for it was I looked at that specific race and said, I think I can win it. I think I can win the election, but just as importantly, I think I'd like being an appellate judge. I'm well suited for this kind of work. It's very quiet and studious and flexible, and that's really what I was looking for. So I decided that I'd like it and I'd be good at it, and combine that with, okay, I would take a chance. But when you're a Court of Appeals judge and your work is being reviewed by the Ohio Supreme Court, it doesn't take very long before you think, I think I could do that. I could review these decisions just as well. And that's when I really started to talk to people about, what would it be like to be running a statewide campaign and the work of the court. And the 10th District was a great training ground for me. Just the breadth of work at the 10th District is is similar in a lot of ways to what we do here. So I felt like I had the right background to be on the Ohio Supreme Court.
And how many years now have you been on their court?
7. I was at the 10th district for 8 years, and I've been on our court now for just over 7. Long time.
Yeah, well, I'm going to come back to kind of the things that you enjoy and others, but I'd like to talk about kind of the big issues now. I mean, here we are doing this by Zoom, and it's a whole different day as a result of this pandemic. And so I'd like to know, how is the court operating now? For those who are watching, who plan on filing with the court or appearing, what's changed? What's a daily operation of the court look like, not only for you, but for the litigants?
Well, like many of you, most of our employees are working from home. So we've got really just a skeleton crew here at the court, and it's open only for official business. So that we don't have those thousands of school kids coming through and all the meetings that typically take place here at the court really can't. And so the clerk's office, of course, is open. The biggest change for the justices are the virtual oral arguments. I'm the only justice who lives in Columbus. Everybody else comes to the courthouse. So we have virtual arguments. Both we and the litigants are virtual now. And so we're really, we're adjusting along with everybody else. We've issued a number of orders about our filing requirements. All of those filing deadlines were told, as they have been in other courts around the state. But we recently lifted that tolling and said, given that we're pretty well set up for being socially distant and still getting our work done, we're going to lift that tolling. But if a lawyer moves for a continuance or files for leave to file an untimely document, tell us that it's because of COVID-19, and we're going to grant leave. We're going to grant that continuance. So we're trying to keep the work flowing, but at the same time, really trying to take steps to keep everybody safe, keep our employees at home, keep the litigants and the lawyers away from the court in a physical way as much as possible. I'm so glad that we have e-filing that really can make that so much easier and really makes it possible.
And so from the video arguments, and you've had now a few days of them, I believe, since the beginning. What would be some tips that you would give to those who are presenting virtually to kind of best deliver their argument?
Yeah, well, some things haven't changed. What still is the same is the best way to have a good argument is to have a good brief. And that's really where you're going to make your best arguments is in your brief. That's where you're going to set up your propositions and your analysis and really the structure for your case. The other thing that hasn't changed is that when you think about getting ready for an argument, think about that roadmap. What are you going to say to the court? What do you have time to cover in the 15 minutes that you have? And so narrow all of those issues down the way that you would no matter where you're going to be arguing from. But I think obviously it's about your surroundings. And this is not a time to try to be creative in your background or have a virtual back. I mean, you just, keep it simple, keep your notes accessible, keep your water glass accessible, make sure your camera's okay, your audio's okay. Absolutely do moot courts. It's not just about getting those butterflies out, but this is a great opportunity. I think moot courts become even more important when you have to deal with new technologies. Now, I think most courts, I know our court does have a practice session or two. Absolutely take advantage of those. Keep those emergency numbers handy in case the number gets dropped. We have practice sessions before oral arguments. The best thing I think really is to watch other sessions. Now, if you watched our first set of sessions a couple of weeks ago, it was okay. It was effective for our needs, but it wasn't pretty. We have since changed how we do them. So the last couple of days we did it by Zoom. and you could see all of the justices on the screen at the same time. Everything just worked so much better with using Zoom. But I think you really have to just get comfortable with that kind of technology. Now we're pretty forgiving. You know, we're all learning this. We're all learning it together. But I think you have to watch the sessions from this week if you're thinking about arguing in the near future. I think it's really, one thing is it's all just distracting. You know, it's distracting for us. It's actually a little bit easier for me because I can see all the justices. I can read their faces. I know when somebody's going to jump in and ask a question. So it's a little bit easier when I see everybody, but you all know that it can be awkward. You know, it's awkward to jump in and ask a question. It's awkward it's hard to maybe hear where the question is coming from. So I think you have to watch some of those sessions and get an idea for how we do it. You know, when we're on the bench, most of the time we take a break, for example, after the second argument. Well, we haven't been doing that quite so much with online arguments. The nice thing for me too is I can see the clock now. The clock is in one of my windows and you'll be able to see that as well. But if you haven't watched one of our arguments, you don't know that if you are the appellant and you run out of time, chances are the Chief Justice is going to give you another 30 seconds to give a rebuttal. So, you know, if you didn't know that, you wouldn't be comfortable. You may not be ready for that. For me personally, my setup on the bench is just better. I have more room. I have more room to take notes. I've got the water glass. I've got my files. I've got the laptop in front of me. And my office is not set up in quite the same way. And so for me, for example, there's this rule at the court. You can only drink water on the bench. So there's a water glass that has my initials and it's on the bench. And that's the only thing I'm allowed to drink from. Well, if I'm in my office, I am going to drink whatever I want to drink. You're going to see me moving around. I mean, if I lean down to write, you might see me lean down. And I think to have all 7 of us on the screen potentially doing that is just really distracting. So if I were thinking about getting ready for an argument, I would watch some of them and just see what those distractions are. I think it's important too to watch other lawyers and kind of get a handle on what looks good on the screen. You know, if I were you, I would either sit or stand. I wouldn't do both. I wouldn't try to, you know, sit during one argument and then stand up when it's your turn. Sometimes that can be a little distracting depending on the view of the camera, the perspective. But just all of those things of when is it, you know, if I'm really leaning into the camera, like some people might, is that effective? So I think one of the best things you can do is just watch what other people are doing and learn from that. As in any argument, the key is to answer our questions. You know, I think if I'm asking a lawyer a question, I'm giving a gift. You know, I'm telling you, this is what I'm concerned about. I'm about to go vote on your case, and this is what I'm still concerned about. And so I think it becomes even more important to really focus in on who's asking the question and to be clear about those answers. You know, the last thing I will say is just, we want you to do well. We want everyone to come in and have a good argument. We know that your colleagues are watching, maybe your friends are watching, your parents are watching. And really, the better you perform, the better we are able to decide the case. And so we're pulling for you. Nobody's trying to trip you up or to make you look bad. We're just trying to get the best information we can. So I know some of you are probably thinking about, should I even have an oral argument? You know, it's difficult for a lot of lawyers anyway, and you add in this new method of communication and it can be that much more difficult. I absolutely think that you should take advantage if you can. If money and time allow, take advantage of that opportunity to be in front of the individuals who are going to decide your case and if nothing else, just be there to answer the questions. So I put a lot of this information in an article that was just published on Attorney at Law Magazine, an online attorneyatlawmagazine.com. And some of the things that I have been thinking about and that lawyers have been asking me about. But you know, it's a great opportunity to try something new and give us information as we're all trying to learn this new medium. So I would absolutely take advantage of that time to have a virtual argument.
That's great. Now, what if there is a practitioner who says, you know what, I want to present in person?
Yeah.
How is that handled?
You know what? To my knowledge, we've not had anybody say that yet. My guess would be it kind of depends on why that is. You know, I can tell you for my personal purposes, having a virtual argument is every bit as effective for me as if I were in the courtroom. Now, if somebody, for example, came in and said, I don't have the technology to do that, we have a lot of people here who would be happy to help with that. So maybe an alternative would be that the lawyer would come to the court and would be able to be in a private room, distant from everybody else, and have our IT team set that up. So I think there are some alternatives to just not doing it. But I don't, from my perspective, I don't see an advantage of waiting and being with us in person when it's just as effective to have it virtually.
Okay, well, that's good to know, because obviously there are a lot of practitioners out there, you know, who may be a little shy of the technology or may not understand it and are therefore fearful. So who would they contact if they don't have the setup at home right now? Who would they reach out to get that assistance?
I think for now I would start with the clerk's office and explain, you know, if you've got an argument scheduled that you don't have the technology to do that. Now there may be others who would be contacting you anyway, but we have the most incredible staff here, and they are service is their number one goal. So I am certain that there would be assistance for anybody who just isn't comfortable with it. I would also encourage lawyers that, as I said, we're pretty understanding. You know, each of us has a different level of comfort. I will, even though this makes me look so completely silly, I will confess that my first meeting a month ago, I spent the entire time looking only at myself because I didn't realize that I could adjust the view and see everybody else who was on the call. I don't know if they knew that or not. So you know, I think we're pretty understanding that this is all new for everybody. We don't expect perfection. We're all learning together. There will be times, not only do we have to say to the lawyer, you're on mute, but somebody might have to say to one of the justices, you're on mute. Justice French, turn on your microphone. So that's why I would encourage you to just watch them. You know, it's not something to be intimidated by. Once you get over that technology, I think just like with any argument, once you get into it, you know, those of us who really love that oral argument debate back and forth and the dialogue back and forth, it can feel the same even when done virtually.
Let's talk about kind of evolution for a moment. Mm-hmm. Things change. The courts today look very different than they did 20, 30 years ago in procedure and so forth. What do you see the legal landscape here in Ohio looking like post-COVID? I mean, we've been in a horrible and tragic situation, but from it and from any tragedy, there's opportunity. Mm-hmm. Yeah. What would you hope to see us take from this to kind of reshape the landscape looking ahead?
Yeah. Great question. You know, it's something that I do think about a lot, of just what are we learning in this process? And I think technology has got to be at the top of the list. One thing that this has done is force courts all over Ohio to upgrade their technology. And the Chief Justice has really been at the forefront of trying to do that over the last several years, not just over the last couple of months. I've been part of, just going out and doing the Publishers Clearinghouse check presentation to some of the courts where they can upgrade their case management system, which ultimately leads not only to more efficiency, but more accessibility. And so I think with all of these new technologies, in the end, it makes our courts more accessible to the public. And I think that's a great thing. So I know just in the past 6 weeks, the Chief Justice has been authorizing a number of technology grants for the local courts who said, I can't possibly do all of the things that I think I'm supposed to do with the pandemic because we don't have the money. Then the Supreme Court is able to provide that money. And it's not the kind of a grant system where we really, we say, this is what we want you to do, and so we'll give you the money. It's the local courts saying, here's what we think we need, here's what we think it cost, here's what the cost is, and then we provide the funding. So I'm sure, and many of you would know better than I, that the same thing is happening in the law firms, where law firms maybe didn't invest technology, maybe for their lawyers, but not for their staff, that we're going to see a lot of technology upgrades. And look how quickly we've adapted. I mean, I have weekly conference calls now that I think, why can't I see everybody? Why am I doing this only by audio? And so I think that I'm not going to go back to just having audio calls. I'm going to try to reach out to people virtually and be able to make that as part of my service.
Thank you. All right, so I kind of want to change direction here for a moment. A lot of, we're made up 88 counties and all of the courts within, and everyone's trying to figure out how to get back to whatever the new normal is going to be, but really open the courts and start moving ahead. I think that some of the difficulty, as you know, from practitioners has been that all of the courts are handling things differently. And some of one of the common questions that I hear from practitioners is, why can't we just get a mandate from the Supreme Court? Why can't the chief just say, look, here's what it is, 1 through 10, and you have to follow it? That would make it easy, because practitioners wake up, they may have 3 matters, and the 3 courts are handling it entirely different. So perhaps you can respond to that.
Yeah, it's a frustration that I sometimes share. One thing to keep in mind, and maybe the key thing, is that we are not a unified court system, meaning we are not the kind of system where the Supreme Court tells the lower courts specifically what to do. We do have a rulemaking process. We do have rules of superintendents. We have rules of procedure. And so we can, in some way, control or take initiative within those rulemaking processes. But we have very, very limited authority. The chief has very limited authority in specifically directing what a court can do outside of a specific case. Now, I think both the court as a whole and the Chief Justice have been issuing guidelines to say, here are the kinds of things that you ought to be doing. You need to be continuing jury trials unless there's some sort of urgency to them. For example, speedy trial requirements. If you do have a jury trial, you need to be excusing jurors who express concern about COVID-19. You need to be making sure that your employees are safe, that the lawyers are safe, that the litigants are safe, all of those kinds of things. So we've been issuing all of these things. As you said, there is some inconsistency there. And so there may be courts in various counties that look at their specific numbers and say, there's not as much danger here in Northwest Ohio as there is in rural Northwest Ohio as there is in the city of Cleveland. And that's true, but I think what you raised too is just the question of, but the concern is the same. The lawyers coming in are concerned about their own safety, the litigants, the jurors, any of the employees, the bailiffs, everybody who has to be there. And so, we've tried to kind of walk that line between specifically without having a specific case in front of us saying, this is what you must do, but at the same time encouraging local courts to really take these things very seriously And, I have to say, I hear very little complaining about what the local courts are doing. Now, that's not to say that there haven't been a couple of specific actions or circumstances that may have needed correcting. But overall, I think the judges are really trying to do the best that they can, trying to balance what are the rights of the parties, how do I keep the court system moving, but at the same time, making sure that everybody is safe. So, to your point about there's so much diversity here, that has been a frustration for me in other areas too. So, for example, we recently voted on a poverty affidavit that is now uniform for the state of Ohio. We didn't have that before. It took, gosh, for anybody on this call who was part of it, it was an amazing process because it just took maybe a couple of years to finally get it through the process and to make it uniform. And as you said, you might be a practitioner in a number of different counties. Imagine the legal aid organizations that are in all these different counties and having to deal with, everybody's individual poverty affidavits. So there are some things that we can do to make uniformity among the courts. There are a lot of things that we can't do. So I share some of the frustration, but I also applaud the ingenuity of the local judges to really take charge of what they think are the correct, is the correct path right now.
Let me ask you, you indicated it's frustrating at times being not being unified court state. Should we be? And if so, how does that process, because we're one of the very few states that's not. Actually.
Right. Yeah.
So why is that, and should that change?
I'm sure somebody out there has the right history of why we look so different from other courts. I think I'm sure from the Supreme Court perspective, there are a lot of really positives to being a unified court system. On the other hand, when you think about how diverse Ohio is, and there is something to be said for this individuality of the courts being able to adjust to what they need and what works best in their individual county. Look at what Cuyahoga County is doing and how proactive the courts in Cuyahoga County are being to really put together one group to say, how are we going to deal with that? Would it be better if the Ohio Supreme Court came in and said, this is what we want you to do? I don't think so. I think having that local authority and responsibility can be a really positive thing.
Okay. Well, and you bring up, obviously my hometown, Cuyahoga County, and I'm as president of the CMBA, I'm part of that the legal task force, the COVID-19 legal task force, and it's been tremendous. I'm going to give you a little bit of background, but I fully recognize that I've got to pull the reins back because this is a case that the court has recently addressed and it may be revisited. So if I go too far, please just stop me. But I want to give a little bit of background to the viewers. Recently, the court was presented with a writ on behalf of a defendant for a judge that wanted to go forward with a jury trial this week, beginning this past Tuesday. The court, in sum, basically said we're going to defer to the discretion of the trial courts. There were a couple of conditions that were imposed. Number one, check for temperature. Anyone who's north of 100 cannot walk into the room. And if there are any jurors that express concern about being there, they're to be released. And that's the short version of it all. I was asked to get involved and appear on behalf of the lawyer trying the case in the Ashland court yesterday, which was the second day of trial. They had engaged in the voir dire on Tuesday. And without getting into the issues, I'm not going to ask you, what do you think about this? Okay. What do you think about that?
We don't want to get a recusal. Yeah.
What's that?
We don't want to get a recusal.
We don't want to get a recusal. That's right. Mm-hmm. But there were a lot of observations that were made and I would venture to say respectfully, and despite the court's best intention, there were some, I think, deficiencies that were probably that no one could anticipate or hadn't anticipated. And the judge afterwards in the media said, well, this was rolling it out. I think it was a pretty good job. We're all learning. What I would say to you, Justice French, is that when we're dealing with people's lives, the time to learn is before they enter the courtroom and not afterwards, where people can be hurt and potentially die over this. And the other concern is maintaining people's constitutional rights. Now, I'm a criminal defense lawyer, but I don't believe this to be a defense lawyer question. I think this is a lawyer question because this affects the prosecutors, court staff, judges, and everyone. And so my thought is, has there been any consideration to putting together a task force by the Supreme Court that includes prosecutors, defense lawyers, court staff, possibly even court reporters, bailiffs, so forth, to talk about all of those things? Because I just want to give an example that anyone from any discipline can appreciate. Now with masks on, it's incredibly difficult to present your arguments in court, and you've got to take that mask down, which puts you in greater jeopardy. People who are high risk, whether they're older practitioners or people with pre-existing conditions, they're going to be different sorts of candidates for returning to courts than perhaps others. Basic trial procedure. How do you approach a witness now? How do we give them documents to refresh their recollection or impeach them? And the list goes on and on. So the difficulty really is, we're either going to find out that people were hurt or your court is eventually going to be inundated with challenges to constitutional violations. So right now we have a very good opportunity to really get some uniformity and solve some of these questions. And I wondered if the court has or would consider putting together an emergency task force, somewhat like Cuyahoga has done to deal with these issues, so that 88 different counties and all of the different levels of court within don't have to try and figure it out on the run, making the human beings kind of the test subjects.
Mm-hmm. Well, you raised some really important and challenging questions. To my knowledge, there is not a task force in place per se. There is, however, the Ohio Judicial Conference. Former Justice Paul Pfeiffer is the executive director of that now. And so that's really been where those kinds of ideas have been vetted. As you said, there is a task force in Cuyahoga County. There are task forces in other areas. But I'm not aware of sort of, I guess, what we could call a task force where there isn't already a task force around Ohio. But I can tell you that the Chief Justice has been very responsive when concerns have been raised in general. I think Justice Pfeiffer has been responsive. I know I've asked to get him to be involved in a couple specific instances where there might have been a downfall and maybe some of the some of the protocols. But I think we're kind of walking this line, not to talk about that particular case, because that wouldn't be appropriate, but really walking that line where we're talking about a case that gets filed, which would potentially be, and that's not the only one, we've had other types of original actions that get filed. Our authority as we're looking at an original action is limited. Those are extraordinary remedies. And so no matter how difficult the problem might be, when I get any type of a case like that, whether it's a prisoner who is filing a habeas petition because he wants to be released, or it's a litigant who doesn't want to go forward, or more likely a lawyer who doesn't want to go forward on a domestic case that's been scheduled for trial, I'm still bound by those appropriate standards of review, and the appropriate powers are there. So we're always kind of walking that line between not what would I want to do personally and what would I do if I were the trial court judge, and second guessing that trial court judge, but what do we have the authority to do? And so we've issued a couple of different rulings in different kinds of cases. I would say we've had at least a handful of them come in these different situations, and you see that line. You see us walking between here are the protocols that are out there, not just by us, but the protocols issued by the governor and the health director. And how do we make sure that those are followed, but at the same time respecting the limited authority that we have. But aside from looking at specific cases, I think your idea of a task force is a really good one. And I think that's something that I should present both to the Chief Justice and to Justice Pfeiffer, that maybe the Judicial Conference would be interested in looking at, and maybe they're already doing it and I'm not aware of it. So those are important questions, and I hope you and others keep raising them.
I assure you we will. So, thank you. So, I want to loop back to some, you were talking about being on the 10th District Court and talked about campaigning and so forth. I have to imagine that campaigning is very different today. And you happen to be in a campaign.
Yeah.
And I'm sure that it's very difficult to get to the breakfast, lunch, dinners, and so forth. So what is campaigning today? What's that look like for you?
It's frustrating. I hear the same thing from President Trump and Joe Biden, from their campaigns. I think anybody who's a candidate right now at any level in the United States and probably around the world, I think it's frustrating is probably the operative word of the day. When this was happening, I was in the middle of the chicken dinner season. This has saved the lives of a lot of chickens by having those dinners canceled. But obviously, any candidate, kind of the traditional movement is you keep moving. You go talk to groups, you go to a rally, you go to a chicken dinner, you go to the breakfast, you go to the spaghetti dinner. There's a lot of dinner, there's a lot of food involved, fairs, parades, all of those things where you're just trying to touch people. I can't tell you the number of hands that I shook. The couple of weeks before this all happened, I was kind of sweating bullets that first 14 days, thinking, my gosh, I probably shook a couple hundred hands in the last few days. So it is different. But just like with practicing law, it really does force you to think differently and to think about touching people in a different way. I just don't think, especially this year, we're not going to go back to traditional campaigning. Those kinds of things aren't going to be available. I don't know that we'll have any parades this year, but it does force you to be responsive in a way that you may be, that I didn't have to be before. So even aside from the campaign, there's service. I pride myself as a justice in getting to all 88 counties. I am on my 5th time getting to all 88 counties, and I can't do that right now. I can't be all of those places. So as both a justice and as a candidate, I'm looking for ways now to meet virtually. And this is a good way of not just talking with one individual, but talking to the members of the Cleveland Bar Association. So I'm looking for these kinds of opportunities, and I think that's what I should be doing as a justice, whether I'm a candidate or not.
Well, and I do want to point out for anyone who's watching, when you talk about service, one of the things that I thanked you for before, and I want everyone to know, you come in from Columbus. This isn't your first time coming to the Cleveland Metropolitan Bar. I mean, you've come in every time we ask, and you were there teaching the new lawyers at our new lawyer boot camp and so forth. So you really are all around the state doing those things. And so in line with service, you're also speaking to someone else who believes in service and wanted to be a lawyer since pretty much as far back as I can remember.
Yeah.
What does being a lawyer mean to you?
Yeah. Well, I think that role, that word service really sums up the most important role. When I talk to high school students now, the interest in the legal profession took a little dip over the last several years. And what I tell them is, look, it gives you, being a lawyer gives you the opportunity to help people. It gives you the opportunity to be in service to your community. And when we think about our leadership, whether it's at the state level or the community level, lawyers are right there at the center. You know, for me, I'm a pretty visual person. And when I think of the legal profession or the judicial system itself, I think of that beautiful old courthouse, you know, that stands. We have them all over Ohio, a beautiful old courthouse, maybe on a public square. And they really represented a time, I think, when that courthouse itself was the center of the community. And as I've moved around the state, I see that that may not entirely be true anymore, that that the courthouse itself is the center of the community. But everywhere I go, the people who work in that courtroom absolutely are the center of every community, whether it's the judges, the people who work there, the lawyers are the ones there right there in the community, serving on city council, doing pro bono work, doing bar association work. You know, they're not just serving their clients, they are serving the community as a whole. So there is something, I think, about having that law degree and maybe the confidence that goes along with that in the way of thinking about problems and problem solving that I think leads directly into serving in whatever capacity a lawyer is called to serve.
Thank you. So I want to kind of give you some of the questions that we're getting from some of our viewers.
Sure.
And one of the questions is, Justice French, what do you consider in deciding whether to take a jurisdictional appeal?
Yeah, good question. Because I think differently about it now than I did as a lawyer. The first question that I would want to answer is, who cares about this case? Who would be impacted by this case? And what I always thought about first as a lawyer was, let me tell you how wrong the lower court was. Let me tell you why that decision was wrong and it needs to be corrected. And that's really not the first question. The first question is this an important question that will have an impact on more than just these two parties? And so if it's about these two parties, that's probably not something that we're going to take in unless it's something that we see frequently about similar parties. One way that I would make that showing that I wish I had thought more about as a lawyer is to try and get an amicus to come in. I think most lawyers think about filing and getting an amicus to come in at the merit stage. But if the whole point is to tell us the impact that this case could have on the broader community, whatever that is, boy, having an amicus come in to say, this isn't just about these two individuals. It's not just about this criminal defendant. It's about many criminal defendants, or it's not just about these two businesses. This is an issue that lots of businesses face. And so that, to me, is one great way of getting your case in. I'm still surprised at how few we get, but then I think, well, I didn't really file many of them either. So if I were looking at that again, that is one thing that I would do really differently. And is there something new to say? You know, even if a lot of people care about it, but we just addressed it a few years ago, what is there about this case that makes it important for us to look at again? Is there confusion about a prior ruling? Is there some confusion out there in the courts of appeals? You know, one thing I didn't do a lot of was try to get a conflict certified. And at the 10th district, it was really hard to get a conflict certified. So for those who aren't familiar, if you get a decision from your court of appeals and you think that that decision conflicts with a decision out of another district, you can have your court of appeals certify that to us. And it comes in on a separate track from the jurisdictional. So now you've got two shots. Now you've got a shot that says there are conflicting opinions out there, and then you've also got your jurisdictional memo. I can tell you that the Supreme Court, I learned this pretty quickly. At the 10th district, as I said, it was really hard to get those conflicts certified. But once they get certified and they get into the court, we are granting, I don't even know what the percentage is, but it's well over half of those that come in as certified conflicts. So if I were thinking about filing an appeal, the first thing is to think about, can you get a conflict certified?
That's great. So another question, I don't know who this person is, but I think it's fair to say that this is a law student, and you'll know why by the question.
Okay.
And the question is, when might we expect the court to make a final decision regarding the July bar examination?
Good question. I'm glad you asked that. I would say very soon. I would say at least by within the next few weeks, the next couple of weeks. We know that people are really waiting for that decision. There are a lot of things to consider. It's not only about Ohio. You know, there's a national part to the Bar Association, so we've got to coordinate with the National Bar Exam Organization. And so there are, you know, all kinds of things about social distancing. Do we have the space? I think we probably do at the Roberts Center. If, you know, we've got usually 1,000 applicants, maybe if do we have 6,000 square feet that we could, you know, that we can keep people distanced away from one another. So there are a lot of different, it's not just about us and what we want to do. It's really trying to coordinate, but we are aware that you're waiting on that. I think it's fair to say, I cannot speak for the other justices. I cannot speak for the court. I think it's fair to say that there will be a bar exam, but we're just going to have to decide what that looks like. Is there a follow-up bar exam? Is there an opportunity for 2 bar exams rather than just 1? But if I were a graduating law student, and congratulations to those of you who are, I would not be sitting back saying, oh, there's not even going to be a bar exam this year. I think it's a safe bet that there will be a bar exam. We just have to decide what that looks like. And for those who have passed the bar, you know, we've got a bar admissions ceremony coming up in a couple of weeks. So obviously that's going to have to look really different too. We can't have all of the new lawyers showing up to be sworn in at one of the theaters in downtown Columbus. And so that will also have to be a virtual event. Unfortunately, that's always one of my favorite things as a justice is being part of that. But like everything else, we're going to have to change that.
Kind of a follow-up question for law students, kind of given the current employment market, and it's obviously suffered because of the pandemic. Do you have any advice for graduating students as to how to deal with kind of this new job market that's out there?
Well, I certainly recognize the challenge right now and what the market looks like, and things just feel uncertain. You know, for all of us, everything feels uncertain. So I can appreciate that this is a very challenging time for you. One of the things that I would be thinking about is, well, number one, this will pass. You know, if there's one thing that I've learned in 30 years of practicing, it's that change happens. And those of us who have practiced that same 30 years knows that there have been downturns in the market and in the economy that eventually corrected themselves. So be assured that this will change, that this will pass, and eventually we will get to a point where the market adjusts itself. Having said that, you know, I would be looking for opportunities to fill in your resume. I love the prospect of law students working to do pro bono work to help with legal aid organizations. It helps, not only are you doing something good for the community and for those organizations, but you're filling out your resume. You know, you're getting an opportunity to speak one-on-one with a client and help that client through a particular circumstance. Not every new lawyer gets to do that. And so when it's time to get your resume out there to a healthier market, you're going to have those things on your resume to say, you know, I haven't been, maybe you have had to take a different kind of job, but at the same time, I've still been keeping those legal skills up to par. I've still been getting ready to practice law, and know that this will eventually correct itself, and we will be in a better place.
Another question that's come in is, how much, I guess, do oral arguments actually influence the decision-making process? And most of the time, do the justices come out having an idea what they want to do, and arguments are really for those cases that are on the fence, or they come out just with a complete clean slate and waiting to hear arguments?
Yeah, good question. If the question is how often does it change my mind? Not very often. You know, it probably happened more at the 10th district than it does here. And I think that probably just reflected the diversity in the quality of the briefing, where you took every case, no matter who was arguing it, and it wasn't until, it would be a very rare circumstance where I got to oral argument and it completely changed my mind. Now, it did happen, but that again reflected that I just didn't get it. Like, I just didn't get what the case was about from the briefing. That really doesn't happen at the Supreme Court. Now, having said that it generally doesn't change my mind. If the question is, are oral arguments helpful? Yes, they are absolutely helpful. I think the whole purpose of oral arguments is to bring clarity to the issues. You know, it's to get my concerns answered. It's to get my questions answered. And the other thing too is that it's about hypothetical questions, which I never liked as a lawyer. I thought they were just tricks of some kind. But now I ask a lot of hypothetical questions. And the reason I do that is that I'm thinking about the next case. I'm not just thinking about this case. We have to think about remedies and how broadly to make them. We have to think about the analysis, how broad to make that. And so when I ask you, okay, let's change the facts up a little bit, and the injury is something different than what it is here, now what happens if we agree with you? And so there's just no substitute. There's no substitute for being in front of the people who are gonna vote on that case, than to have that kind of dialogue. So I may have said, short of money and a time constraint, I would not give up that opportunity. Are there cases where oral argument isn't needed? Yes, but I don't think the lawyers know which ones those are. I think you can only know that if you can see whether I've written out my questions or not. And so I would, even if you are appointed counsel, that's the kind of thing that we would see at the 10th district. For example, in a criminal case, you've got appointed counsel. They sometimes would come in and say, I think we can stand on the briefs, but I'm here to answer your questions. I loved that. I thought that was a great way of accommodating, not having to spend too much time, but to be there to answer questions. And sometimes we would have questions and sometimes not. But if the other side waives, I would absolutely not waive. You're going to be the only lawyer in the courtroom if the other one has waived and you've got these oral arguments to yourself. So I would absolutely take advantage of it.
That's good advice. So the next question that comes in ties in perfectly with something that you said to me when we were speaking and preparing for this interview. And I found it very interesting. You said lawyers need to feed their souls right now. I thought that was a great statement, which I'm going to ask you about to elaborate in a minute, but I want to read the question to you, and you'll see why I think it's very timely. The question is that the legal profession is one that produces a significant amount of stress for practitioners. How do you ensure that your mental health is as strong as your physical health when you work in such a demanding environment?
Yeah.
And so I think that ties in very well to your statement, and I'll let you kind of address both of those.
Yeah, this is something that took me a while to learn, and I don't know that I've learned it perfectly, but I think there is something about whether it's the people who become lawyers, those of us who become lawyers, or the legal profession itself, that we tend to be hard-driven, focused individuals who want to solve problems. And that can lend itself to a lot of stress, whether it's physical stress or mental health stress. So I do think that it's really important. I think number one, to recognize that it's important, that your mental health is important, and it's just as important as your physical health. Although I think all of us would admit sometimes when you're mentally, when you're mentally stressed, that's when your physical stress is also you're gonna see it in that way as well. But, you know, one word that I've tried to get rid of from my vocabulary is workaholic. I think a lot of times, I know I've done it. I've done it in my career. I've expressed pride in being a workaholic, and I don't do that anymore. I express pride in trying not to be a workaholic and to have balance in my life and to have friends and family and people that I love and things that I can do outside of work, or whether it's being a candidate or being a justice. And I think you have to work at that. I don't think it's automatic in this profession. I do think that the newer lawyers get it. I think they get it better than when I came out in the 80s. That I think was really the time that, you know, you thought that you had to work those crazy hours, and maybe we did at that time, but I think that the newer lawyers tend to see things a little differently, and I think that's a really healthy thing. But there is, it takes practice, I think, to get yourself mentally in check, to say, I'm going to take care of myself. I can tell you that particularly out on the campaign trail, it can get, you know, you do get out of balance. And I'm not saying that I or other people can't be out of balance. Sometimes, of course, you're going to be. You're going to be, you know, getting ready for a trial, you're getting ready for a presentation, whatever it is. But in the end, to say it's important that I remain mentally healthy and that I learn how to be centered. You know, that was something that I really had to take a lot of time to think about. So whether it's mindfulness or spirituality or prayer or whatever it is for you to be able to quiet your mind and get yourself centered. So I am by no means perfect at it, but I am getting better reminding myself that that's important.
And so lawyers needing to feed their souls right now. I think it's an individual action, but also I think that it would be good for the profession and for the lawyers to really be helping the souls of our colleagues as well. And I kind of like your thought on that. And then I've got one final question, a personal question for you. But how do we take care of our profession right now? I mean, we're in an adversarial system.
Yeah.
We've got all sorts of interests, moving cases, winning cases, losing cases. But first and foremost, as you said, we all walked across the same stage. We're all lawyers first, regardless of whether we're the judge at the highest level or we're wherever we are. We're all the same.
Yeah.
How do we help each other right now?
And I think, again, it starts with an acknowledgement that that's important, that the person across from you, whether it's a colleague or an adversary, is somebody that needs your respect. This is a very a simple example, but on the bench, when I'm speaking about the opposing counsel, I tend to say, your friend on the other side. A lot of lawyers after arguments will shake hands. You know, I think there are a lot of ways that we can simply show that we respect one another, that we can leave the adversity behind us and be able to, be able to show that concern for one another. We do have a wonderful program in Ohio. The Ohio Lawyers Assistance Program is for those people who are feeling like you need some assistance. It's for people who have not just an addiction problem, although that is certainly one of the reasons that you might want to call. But the information is available on the Ohio Supreme website for assistance to lawyers. What do I do if right now I feel like I'm losing it? I feel like my clients are disappearing. I'm not getting my hours in. I can't handle all of it. There is a resource for you as a lawyer. It is specifically for lawyers to reach out and take advantage. So I would be remiss if I didn't remind all of us that there is an Ohio Lawyers Assistance Program out there that any of us can take advantage of.
Do you have a website up for people to learn more about you and the campaign and so forth?
Yeah, Justice Judy, Judi, JusticeJudyFrench.com.
All right, and Justice French, I'm going to ask you one last question, and it will be 30 seconds. Tell us something that we don't know about Justice French, something that would surprise us, something that's funny. what is it about you that
Yeah.
none of us would ever think?
I'm a Trekkie.
You're Trekkie. Okay.
So
Well,
with
that's
that, I'll give the greeting, or I'll say to each of you watching, live long and prosper.
and there it is. So, Your Honor, it has been a pleasure. Thank you for
This
being
has
our
been
first
fun. Thank
guest,
you.
and you've been such a friend of the Bar Association and to our profession, and it's really been an honor and a pleasure to speak with you today. Thank you,
Thank you. This has
and
been,
stay safe. And I look forward to seeing you on the other side of this.
thank you. I do appreciate this, and thank you for all of you who are watching.
Thank you, Your Honor.